in a thoughtful opinion that I did not agree with.
Do you recall that the state filed an objection stating that we believed that that challenge was untimely?
Yes.
And is it your recollection that in spite of that objection that the court did make an order based on the merits of addressing the merits of your claims?
Yes.
I'd like to move on to further claims raised by defense in their motion for a new trial. And some of these overlap a little bit. But there has been a claim made that there was a failure to pursue cross-examination challenging the credibility of a witness or some of the witnesses at trial. And that claim may also interface with a claim that the state may have engaged in selective prosecution or bias of some of those witnesses. Could you respond to the challenges of the failure to pursue the cross-examination of a witness or witnesses?
This relates to what I said earlier about trying the case in a tight fashion. The most harmful witnesses in the case to me were the three friends of Chessie who lived in the dorm with her and with whom Chessie spoke in the immediate aftermath of her encounter with Owen. I felt that if those witnesses were permitted to testify, it would make a difficult case exponentially harder. Normally, their testimony would not be admissible because it did not, in my opinion, meet the criteria for a spontaneous utterance, sometimes called spontaneous exclamation or excited utterance. It would be hearsay and so excluded on that basis. But the most dangerous way it could be admitted is as a prior consistent statement. I'm very familiar with that rule of evidence, partly because I'm the editor and co-author of an evidence book in Massachusetts. I'm co-editor with 4 trial court judges. So I'm very familiar with how a prior consistent statement can be admitted at trial. And what Sam and I focused on every single day is not alleging that Chessie's allegation was in any way a recent fabrication. The definition of recent fabrication is a date after the alleged incident occurred. We were aware that there were things that happened that very much affected Chessie, and understandably so. One was the fact that her encounter with Owen quickly became well known on campus. And so that was the subject of, I'm told, much discussion. And that would be uncomfortable or painful for Chessie. I became aware that Chessie's sister learned that she and Owen had been together. And in fact, there was evidence that the older sister had punched Owen when she next saw him. There was evidence of a Facebook posting that could be viewed as mean in the way kids can be mean. And Chessie was aware of that. And finally, Chessie's parents were returning to Concord, I believe, from their residence in the Far East, having learned of this situation. The most poignant email exchange between Owen and Chessie was on the eve of the arrival of her parents, when she wrote to Owen words to the effect, "My parents are on the way here. This is not going to turn out well." And there was no further communication between Owen and Chessie. We gave a great deal of thought to making that be the linchpin that led Chessie to change her account from a consensual interchange between her and Owen to one that was against her will and by force. But if we had done that, then any statement that Chessie made to anyone prior to that point in time would be admissible as a prior consistent statement, including the three friends in her dorm who would now be allowed to rebut the contention that Chessie is only saying this because her parents are coming to town. And that would be devastating if those prior consistent statements came in. That's why it was our position at the trial that Chessie fabricated that the encounter had been forceful, but that she had fabricated it from the first time she spoke to someone about it after her encounter with Owen. By framing it that way, there could not be any prior consistent statement admissible at the trial. We were vigilant during the trial that we would never suggest that there was any post-event activity, statement, encounter, thought that would have led Chessie to fabricate it. And we were relieved that Judge Smuckler had a deep knowledge of evidence law, including on this law, and he was vigilant during the trial to see if we would open the door. I can remember a couple of occasions when either you, Ms. Ruffle, or Joe LNU, last name unknown. Okay, Joe Chernisky, would approach the court at sidebar and indicate that you felt that I or Sam had opened the door. And we would respond that we had come close. And I remember Judge Smuckler even responding sometimes with his wit and say something to the effect, "Oh, Mr. Carney may have come up and touched the doorknob, but he did not turn it," or words to that effect. And what he was signaling to you is that we had not opened the door, but simultaneously signaled to Sam and me that he was watching very carefully if we did that, and so we tried to be as careful as we could be, that we never examined a witness or introduced any evidence that would suggest that Chessie, after the encounter with Owen, had a reason to fabricate the charge.
Thank you. Your Honor, may I approach?
Yes.
And I'm going to present the court with a document that we're going to ask be marked for State's Exhibit number 7 for ID purposes. Your Honor, may I approach?
Yes.
Before I present the witness with this, may I approach the witness, Your Honor?
Yes.
Attorney Carney, I'm going
Before
to...
you do, Your Honor, may I have my glass of water refilled?
Yes.
Thank you. Thank you.
Attorney Carney, I'm going to ask you to take a look at what's been marked as State's Exhibit Number 2. Do you recognize that?
Yes, I do.
Do you recall seeing that previously?
Yes, I do.
Can you describe for the court what this is?
It's a photograph of Chessie and another young woman, with Chessie holding her arms above her head and the other woman holding those arms at Chessie's wrist. Chessie appears to be leaning against a door.
And do you recall the state's attempt to try to have that admitted at trial?
Yes, I do.
I'm going to now hand you what's been marked for identification purposes as State's Exhibit Number 7. If you'd like to just take a few minutes to review that would be fine.
Yes, I recognize it.
And could you describe for the record what this is?
The bulk of the transcript, which is 3 pages, is a transcript of a sidebar conference held to discuss my objection to the admission of this photograph.
And could you just briefly highlight the significant portions of this transcript in regard to the state's attempt to have this admitted at trial?
Yes, the court asked me, what is my objection? I responded, this is a hearsay statement. The evidence to this point is I showed them what had happened. This is a prior consistent statement, not admissible under any exception to the hearsay rules. It's, as Your Honor noted on a prior occasion, possible for someone to do something as a statement in order to communicate something. That's exactly what this is. The court heard from you, Ms. Ruffle, and then ruled the objection is sustained. I don't think I think the transcript was meant to say intervening, not interviewing.
And I would agree with that assessment.
On line 18 on page 199. I'll read it as I think it was stated by the court. The objection is sustained. I don't think the intervening motive, fabricator, or other foundational elements of prior consistent statement were in the opening or has been raised at this point. I haven't heard it, and then His Honor goes on to say, I haven't heard anything like that would justify the substantive evidence of a prior consistent statement. So my previous ruling with respect to prior consistent statement remains in effect. And this is a perfect example of the interchange that I referred to earlier that I believe I characterized as Judge Smuckler's vigilance in determining whether we had opened the door to a prior consistent statement.
And ultimately, you were successful in preventing the state from allowing this to be entered into evidence, excuse me.
Judge Smuckler, I think, made correct rulings on that throughout the entire trial.
Thank you. I would ask that the ID be stricken on this and this be marked as a full exhibit. To submit what the state is going to request to be marked for identification as State's Exhibit Number 8. May I approach the witness?
Yes.
Attorney Carney, I'm presenting you what has just been marked for identification as
Exhibit number 8, and I would ask you to take the time to review that, please.
I'm familiar with it.
Can you describe for the record what this is?
This is a police report by Detective Curtin of the Concord Police Department that reflects interviews with witnesses in this case.
And does this contain examples of statements that your strategy intended to try to prevent from being admitted into evidence?
Yes.
And can you describe for the record specifically what those statements were in regard?
There were statements made by Chessie following the incident to her friends. Any statement that she made following the incident to her friends, I sought to exclude.
You view these as prior consistent statements that if you were successful, the state would not be able to admit?
Correct.
Can you highlight what you believed would be damaging to the defendant? Specifically, let's go one girl at a time. Are there statements in this report from Claudia that you believed would be
There were
damaging?
statements by all three girls. And the way to identify them is if they made a statement, I viewed it as harmful to Owen, so I didn't want it to come in.
Can you describe generally the nature of these statements?
Yes, it was Chessie reporting to them her encounter with Owen.
And did she detail events during the encounter?
Yes, she did.
And can you describe how they're consistent?
That Chessie described the encounter as not being consensual.
Does she describe activities that you view to be consistent with Chessie's disclosure to these witnesses, potential
Yes.
witnesses?
For example, Claudia states that Chessie said Owen was trying to, in adult language, perform cunnilingus on me. And, quote, I kept bringing his head back up, and then he would keep going back down, and then I'd bring his head back up again, and eventually it just happened. I noticed that both his hands were on the top half of my body, and there was still something inside of me. And then before something too serious happened, I sort of like pushed him away. That is Chessie's account of the incident that she provided at trial. It would be toxic to the defense if Claudia were permitted to state that before the jury.
And in your assessment, these statements made to the other two girls reflected in this report, are those similar
Yes.
and consistent as well?
I haven't read them in detail, but these were the three witnesses we were most concerned about.
And it may seem obvious, but could you just elaborate on why you felt that admission of prior consistent statements would be damaging to the defense?
The reason that prior consistent statements are not permitted generally is because of the belief of court.
I'm sorry, turn the cell phone off. If I hear another cell phone go on during this proceeding, I'm going to direct that they all be turned off, not just in silent mode, if you're in this courtroom. So you're all responsible for everybody else. Go ahead, Ms. Ruffle.
I apologize for the interruption.
No problem.
The question was, why are prior consistent statements damaging to the defense?
Federal courts and every state court that I know of views prior consistent statements by witnesses as improper when offered by the Commonwealth or the state or the federal government. An individual's testimony that an event happened and afterwards she's told Sally Then she told Tom. Then she told Bill. Then she told Gordon. Then she told Mary. Enhances the jury's belief that the original testimony about the event that occurred is true, because the witness has continually been telling people it's true. And courts have held that just because a person repeats a statement doesn't necessarily make it more credible. And so prior consistent statements are not being allowed to be offered, and they are excluded as hearsay. The exception is when a defendant in a criminal case suggests to the jury in cross-examination that there was a motive for why the witness would be lying at the trial. In that case, the role of a judge, having heard the cross-examination, is to identify the motive advanced by defense counsel in cross-examination as to why the witness fabricated a statement given at trial. The judge is then supposed to determine any statement made before that date when the alleged motive to fabricate is alleged by the defense, and prior consistent statements during that prior time period are then admissible. I'll give a short example. Defendant says that state witness testifies, I saw the defendant go through a red light and hit a green car. 3 months later, after the accident, the witness is charged with a crime that's being prosecuted by the same office that's prosecuting the motor vehicle accident that occurred 3 months earlier. Defense counsel suggests in cross-examination that the only reason the witness is saying that the defendant went through a red light is because he's now being prosecuted by the same office and he wants to stay on the good side of the prosecutor. Therefore, the cross-examination is saying that the witnesses being arrested and charged on a particular day is the reason why he's fabricated the testimony. In this situation, the people that the witness spoke to at the scene and in the days after the scene, after the event, can come in and say, well before he was ever charged with this crime, he told me he saw the defendant go through a red light and hit the green car. So as long as defense counsel in cross-examination doesn't identify an event like an arrest of the defendant, arrest of the witness, or the posting of a Facebook comment, or the opinion of her older sister being very upset that they were together, or the arrival of the parents from out of the country, then the prior consistent statement can't come in if the defense position is that the witness, Chessie, fabricated the allegation of forcible sex the very first time she made any statement in this case.
And based on your familiarity with these rules of evidence and these practices, did you tailor your cross-examination to carefully avoid opening the door?
Absolutely true.
I had started this line of questioning by saying, talking about the failure to pursue cross-examination of witnesses and its interlap with the claim of potential selective prosecution. Did you have those concerns in mind when you were cross-examining the witnesses at trial?
Yes.
And can you speak to particularly what your concerns were as you cross-examined the state's witnesses? And I believe specifically the claim is in reference to 3 of the young males that testified that were friends or acquaintances of the defendant.
Raising an issue of selective prosecution is very dangerous in almost every situation. It invites the government to explain why they selected this defendant to prosecute and why they chose not to bring charges against other people that the defense would claim were similarly situated. And this results in very prejudicial evidence coming in against the defendant. In this case, the government's asserted reason for pursuing charges against Owen is not because he engaged in a senior salute, because there was evidence that a lot of people engaged in a senior salute. However, there was no evidence that I saw in the discovery that another person had engaged in a senior salute that had resulted in an allegation of forcible rape. That's one reason why Owen was prosecuted and these others weren't, is what I expected the prosecution to present. In addition, there were a number of references throughout the discovery of other women whom Owen had dated, in which he had acted in ways, according to the women, that were very aggressive, that were forceful, that led to Owen having a very bad reputation at the St. Paul's campus among women as someone who would be so aggressive that he would actually go so far as to inflict injury during a sexual act with a woman, such as biting a lip or biting a nipple that would cause injury that was apparent the next day. This is not evidence that's helpful to us because it would seem to be very similar to the allegations of what Owen did with Chessie. So Owen's reputation for being aggressive, Owen's encounters with other women on either dates or senior salute was not something that I wanted to have admitted at the trial. This evidence was highly unlikely to be admitted at the trial unless I opened the door. One way I could open the door is if I alleged Owen is being singled out for no good reason. So that's why I never, either by motion or cross-examination, made that suggestion in any way.
Because you were aware of that evidence in the discovery?
And that had been contained in a number of items of discovery I had received. It made the idea of selective prosecution a non-starter.
May I approach you?
Yes.
State's Exhibit number 3. Oh, and as a matter of housekeeping, I'd like to ask that the ID be stricken on State's Exhibit number 8 and this be entered as a full exhibit. This is I think she said sure.
Yes, okay, thanks, Sergeant.
Thank you.
Thank you. Your Honor, may I approach the witness?
Yes.
I am going to hand you what's been marked as State's Exhibit number 3. If you could just take a moment to look at that. Thank you. Are you familiar with the exhibit that I just gave you?
Yes, I am.
And is that an example of evidence that you are referring to?
Yes, it is.
And is there anything specifically in that
that highlights what you were concerned could be potentially admitted at trial?
Yes, there is.
And is there an excerpt there that describes, just briefly?
This is an interview with a witness that I will call EW. The witness, her name is on Exhibit 3. The mother of the witness communicated with Detective Curtin of the Concord Police Department and said that she had gone out with Owen, who took her to a, quote, creepy place, end quote, behind the upper. Her daughter was, quote, at risk of something being done to her, end quote, by Owen. The daughter was then interviewed by the police, this particular detective, who related that there was a rumor going around about Owen raping Chessie right before the end of the school year, that she had previously heard about people feeling, quote, violated, end quote, when they had been making out with Owen Labrie. The witness indicated she first heard something like that around the end of April. She heard that he had, quote, scored, end quote, a named person, and that the named person, quote, felt very violated by him. She had heard from other people that Owen was too aggressive and close to hurting her. And that's on the first page. And there are similar accounts by other witnesses.
You refer to page 2, what does she refer to?
The witness stated that she went with Owen, who brought her to a shed called, quote, Mars Hotel, end quote. They walked over to a couch that Owen told her that he and another person had put there. The witness said it was a little too rushed and that he was very aggressive, her language, making out with her. She stated that it felt, quote, pushy, end quote. The witness stated that Owen took off her shirt and bra. Two things then happened that made her feel like she was being violated. Number one, Owen sucked on her lip and gave her a blister, which hurt. Number two, Owen sucked on her breasts, leaving bruises. The witness said it hurt and it was not okay. She went on to say that letting Owen keep doing it was not good on her part. She did not tell him it hurt. And the best way she could put her response into words was a feeling of inferiority of speaking up to him about it.
I don't believe it's reflected in that report, but do you recall ever learning that EW had actually taken a selfie of herself reflecting the injury on her lip?
I don't have a present memory of that.
But do you recall that that the defense was successful in preventing the state from entering this information at trial?
I don't have a specific memory of the state offering it, but I do have a specific memory that evidence of this did not come in at trial.
And would that be because defense did not open the door to allow us to argue for its admission?
That's likely. I just don't have a present memory of the government offering it. And if you didn't offer it because we didn't open the door, then your statement is correct.
May I approach the witness once again?
Yes.
Attorney Carney, I'm now going to show you what's been entered as a full exhibit, states exhibit number 4. And if you could review that briefly, I would appreciate it.
I've read it.
Is this another example of information and discovery that you felt would be damaging to the defense if it were allowed to be admissible?
Yes, it was.
And can you specifically highlight what your concern was?
The witness suggested that when she was with Owen, he suddenly began what she described as fingering her, and suggested that she did not agree to that initially. He felt uncomfortable about it, and there was an abrupt ending. She also talked about feeling his penis, but that he had not actually penetrated her.
And was there more than one encounter with this particular young lady?
If the report says there was, then she reported that there was.
And again, is it your recollection that the state was not permitted to enter this evidence at trial?
My only memory is that this witness's statement about these encounters with Owen did not come into evidence at the trial.
And your trial strategy was intended to prevent that to come in, is that correct?
Absolutely correct.
Your Honor, this would be a good breaking point if you wish to break for lunch.
Okay, we'll break for lunch. We'll resume at 1:30 sharp.
All rise, please.